Hi there, welcome to the 5PB webinar, a tradition now steeped in history because this is our 10th edition, so we're very pleased to have you listening. You can catch up with all our other previous editions, all 9 of them on Crimeline, where they're available in the CPD part. We've got a very interesting couple of talks for you today on account freezing orders and firearms offences. As ever, if you want to ask any questions, there's a Q&A function on the right hand side of your screen, so do fire some questions through to us and our presenters will answer them at the end. We've got 2 speakers today. We're going to finish with Robin Shellard talking to us about firearms, but we're going to start with Tom Quinton talking about account freezing orders. So without further ado, I'm going to pass you on to Tom now.
Thank you, Josh, and welcome everyone. Good to see we've got a bit brighter weather this afternoon than we had this morning. So this talk is about a situation where a client says to you, help, my bank has frozen my account and they won't tell me why. Welcome to my short training video on the Criminal Finances Act 2017. The statute now in force is a potential game changer when it comes to financial crime. The state now has the power to seize the proceeds of crime direct from a criminal's bank account. Previously, of course, your clients could only forfeit money in a bank account as a result of a confiscation order made after they had been charged, tried, and convicted beyond reasonable doubt. But now, in more and more cases, forfeiting money as a first resort will be the preferred route instead of the longer and more risky process of a prosecution in the Crown Court. Now, of course, unexplained wealth orders introduced by the same Act may have attracted the press attention, but these lesser known provisions, which involve the freezing and forfeiture of money held in a bank account without so much as a trial, could prove to be the most relevant in the long run. Even though there may be no criminal prosecution, it's still a step-by-step process. And that is basically what this training video is about, is to introduce you to that step-by-step process. And that process will almost always start with someone asking you for advice because their account has been frozen and their bank won't tell them why. Now, there are 5 results that I want to achieve with this training video. First of all, I want to help you prepare for exactly that question. And I'm going to use a real life scenario by a member of the public asking you a question. Let's call her Joe Public, and her bank account is frozen. And that is really to try and bring some life to these provisions. Secondly, I want to help to reveal what is happening behind the scenes at Joe's bank and at the National Crime Agency. And then thirdly, I want to talk a little bit about what clients in Joe's position can bring to your firm. Fourthly, I want to help you to understand the step-by-step process of bank account forfeitures in the Magistrates' Court. And finally, number 5, have a little discussion about these new provisions and give you an opportunity to ask questions. So let's look at Jo and her problem. She says, my bank account has been frozen. When I ask my bank, they won't tell me why. She's a bit desperate. She says to you she can't even pay her rent. She knows there's definitely money in there. She says, I just inherited nearly 100,000 from my grandfather in Albania, which got paid into my bank account yesterday. So what's going on here? Why has the bank frozen Joe's account? Jo earns 40,000 a year. Her bank account is one of the major Big 4 high street banks. And by the way, they make nearly 250,000 suspect activity reports each year. And the National Crime Agency receives nearly double that number each year from other banks, building societies, bureaux de change, casinos, and of course even from solicitors' firms. So going back to Joe, nearly 100,000 has been received into her account, and the bank's computer has an algorithm designed to spot any transaction that is unusual or suspicious. Typically each month, only about 2,500 goes into her account from her salary, but suddenly there's a big chunk of money, and Albania is on a watch list. So an alarm bell rings and the transaction is brought to the attention of the bank's nominated officer. Let's call him Peter. Peter looks at the information and he suspects it could be money laundering. He presses a button on the bank's computer, which freezes Joe's bank account. So pausing there, why has Peter done this? There are two reasons. First, the bank is in the regulated sector and must have a nominated officer like Peter and such a system in place. Under sections 330 to 332 of the Proceeds of Crime Act, Peter, as a nominated officer, is obliged to report any suspicious activity to the National Crime Agency. If Peter doesn't do that, he commits a criminal offence. Likewise, any other member of the bank is obliged to report any suspicion they have to Peter so that he can decide whether to make a suspect activity report, or SAR for short, to the NCA. Thus, other members of the bank can pass the buck to Peter for him to make the call. But if they don't pass it, they themselves commit an offence. So banks cannot choose to turn a blind eye. They're on the front line of policing money laundering. Banks are the unpaid eyes and ears with everything to lose and nothing to gain. The second reason Peter acts is because the filing of an SAR, if followed by a consent to proceed from the NCA, will provide a defence to any allegation against him of money laundering. The money laundering offences under sections 327 to 329 of the Proceeds of Crime Act prohibit the acquisition, possession, retention, concealment, disguising, conversion, use, transfer, removal from the UK of criminal property, where the defendant knows or suspects that the property represents the proceeds of crime. And being concerned in arrangements with the defendant, where you know or suspect will facilitate money laundering, is also an offence. In short, Peter suspects the money in Joe's account might be dirty, then the bank cannot allow Joe to move or access the money, and Peter must file a report to the NCA. Well, how does Joe discover what's going on? It probably happens because her bank card doesn't work that evening when she's out with friends, and it's very embarrassing. Joe's friend has to pay her bill. Obviously, the next day, Joe phones her bank to ask what is going on. Her card is not working, but she knows her account is not overdrawn. The bank's call centre is less than helpful. They tell Joe to come into the branch. She does that, but they don't help Joe either. They tell her that her account has been suspended, but they cannot say why. Joe is obviously pulling her hair out. So now you're in position to advise Joe that an unusual sum of money coming into her account from a country on a money laundering watch list triggered the anti-money laundering and terrorist financing system at her bank. But why can't the bank tell Joe about the SAR? The answer can be found in section 333A of the Proceeds of Crime Act. It's a criminal offence for a bank to tip off a customer about a suspect activity report, when to do so is likely to prejudice investigation. If Joe was really involved in an international fraud, if she knows the SAR may have been made, it might prompt her to notify her co-conspirators and or flee the jurisdiction. This is unfortunate because In Joe's case, the money was legitimate. Joe could even verify the source of the money. But her bank can't even have that conversation with her because it's now in the hands of the National Crime Agency. But what will the National Crime Agency do? They will review the SAR relating to Joe and cross-reference it with existing information. One of two things will happen. Either the information will lead to an investigation by law enforcement agencies, or the NCA will determine that no further action is necessary. In our example, the bank has to appease Joe, who's becoming increasingly upset as the days pass. If Joe is not a criminal, then the bank don't want to lose her customer. That is why when Peter made the SAR, he requested the NCA notify the bank that it has a defense to transferring the money. Now, if the NCA does not respond to the bank within 7 days, the consent is deemed to have been provided, and the bank can unfreeze Joe's account and hope for forgiveness. But the bank may still be prevented from explaining why the account wasn't working. But what if 8 days or more have passed since Joe's account was frozen? In this case, it means the NCA must have responded to the bank within the 7 days to indicate that it needed more time. Joe's bank now has no choice but to keep her account frozen for up to a further 31 days, and it still can't tell her why. The NCA has to decide what action to take in those 31 days. If the bank hears nothing further in that time, it can unfreeze Joe's account. Now, you've probably taken a few minutes to listen to Jo and explain to her what's going on behind the scenes, and this will hopefully enhance the reputation of your firm. But what if law enforcement agencies have obtained a court order within 31 days, resulting in Jo's account still being frozen? It may be, of course, that a criminal investigation has begun and Jo is notified that a Crown Court judge has made a restraint order against her. That would be part of the everyday criminal defence experience, and you could expect criminal charges and perhaps a trial to follow. But what if the NCA instead decides to apply to the Magistrates Court for an account freezing order? Now, the account freezing order is the first step in the civil recovery process created by the Criminal Finances Act. The new AFOs really signal a change in approach by UK law enforcement, with civil recovery set to become a new norm. If the NCA believes Jo's bank account is being used unlawfully, it will apply to the Magistrates Court for an account freezing order, which, if granted, will be served on her and will explain and outline what has been going on. And for Jo, this is a big deal, because an AFO will allow the freezing of her bank account for up to 2 years while an investigation takes place. And an AFO can be made for a sum as little as £1,000 in the bank account. And the NCA often hand the investigation at that stage over to the police after the initial flying. Well, what do AFOs look like in practice? The Magistrates Court will grant an AFO if it considers there are reasonable grounds to believe that monies are the proceeds of crime or are intended for criminal activity. The court will set the duration of the AFO, usually about 3 months, but the AFO can be extended for a total period of up to 2 years. The money can be in a foreign currency, and the AFO need not necessarily relate to a bank account in this country, because any bank that has a branch in this jurisdiction has to comply with an AFO. Now, before we turn to the forfeiture of money in the account, let's take this opportunity to look at AFOs from a solicitor's point of view. An AFO can be varied to make exclusions or exceptions to the freezing order. And exclusions on the freezing order may include payment from the account to meet the person's reasonable expenses, including their legal expenses. And very usefully, the legislation requires the Magistrates Court to disregard the possibility of your client being able to get legal aid. But of course, the legal expenses have to be reasonable, and the exclusion is unlikely to be open-ended. So in other words, when dealing with civil recovery, your firm could be paid out of monies unfrozen from the account if your client is unable to access any other funds. And there are circumstances in which you might be able to persuade the court to provide compensation to your client. Provisions allow for that if they can show they have suffered a loss as a result of an account freezing order. Or at least an account forfeiture order, which we'll come to, which is the seizing. Now, we've got an AFO in place on Joe's account. So what happens? Where do we go from here? And we're going to refer to some slides because it will make it easier to follow at this stage. Let's just go back for a moment over what I've said about the timeframes before an account freezing order must be in place. So this is before any court has become involved. Firstly, the NCA have 7 days to respond to the bank once the SAR is made. And if the NCA needs more time, it can ask the bank to keep the account frozen for a further 31 days before it has to apply to the magistrate's court for an account freezing order to keep the account frozen. So what that means is Joe can be kept in the dark about what's happening for nearly 40 days. And it's only after the final 31 days have elapsed that the NCA has to apply to the court for an account freezing order. If we turn to the next slide, we'll see what happens once an account freezing order is in place. I'm going to take you through 3 events about what can happen. And these are all logical, but setting them out clearly makes it really easy to understand. Because the first event is the AFO lapses after the period which is specified in the AFO comes to an end. So the AFO usually starts with a 3-month time period. If it just lapses without being extended, then no money is forfeited and the account can be unfrozen. Now, of course, the Crown can apply to extend that initial period. And that really is the first event where they remain involved. They just keep extending it while they investigate and take things forward. If they allow it to lapse, as I've said, no money is forfeited and the account is unfrozen. If we turn to the second event on the next slide, this is where you persuade the magistrate's court to set aside the account freezing order on the basis that the court could never be satisfied any money in the account was obtained from unlawful conduct. So let's assume Joe is able to provide you with documents from a lawyer in Albania who was dealing with her grandfather's will, documents showing that the money was transferred from that lawyer's account, and perhaps even a letter from the lawyer explaining what's happened. If that information is shown to the Crown, and the Crown don't have any evidence to gainsay it, then it's very likely that you'll be able to persuade the magistrate's court that it's legitimate money, and it could never be satisfied that any money in it was obtained from unlawful conduct. And in that case, no money is forfeited again, and the account is immediately unfrozen. It's the third event that we turn to in the next slide, which is where the Crown serves an account forfeiture notice on Joe. And that must state the amount that will be forfeited and the period for objecting, which must be no less than 30 days. So the forfeiture notice says we want to seize £100,000 and that will be seized from the account unless you object in the next 30 days. Now, the result of that is the account remains frozen until the issue of forfeiture is resolved according to A, B, C, or D, which we will deal with in the next 4 slides. Let's turn to A on the next slide, first of all. So that's the first possible response to an account freezing notice. You make no objection before the conclusion of the period for objecting. So the 31 days, which is the minimum objective period, runs without you making any objection. In that case, the issue isn't even put before the court. Time is saved by the court and by the law enforcement agency, because it's automatic that unless you object, the money is forfeited. And obviously when the money is forfeited, the account is then immediately unfrozen. Another response you could make, if we turn to response B on the next slide, is that you make an objection and then 48 hours elapse with no application from the Crown. So there the shoe is on the other foot. Now the Crown have to do something, which if they don't do, then the account is automatically unfrozen without any money being forfeited from the account. So it's very important for both parties, the law enforcement agency and the client, Joe, to be on their toes, because if you do nothing, it could be fatal, it could be disastrous. And we'll come to a discussion about that towards the end. But let's for now return to the third response to an account freezing notice. That's on the next slide, response C. Here you make an objection, but within 48 hours, the Crown apply for the OFO to be extended. So the Crown say, no, we are serious about this. And then we basically go back to the situation where there's an account freezing order in place until something further happens. So that just is a sort of test where the Crown say they want to seize the money, you object to that, and then the Crown know that, and we just go back to the situation where your account remains frozen, perhaps while they investigate things further. They could respond, if we return to response D, though, if you make an objection, but within the next 48 hours, the Crown apply for the amount stated in the account freezing notice to be forfeited. Now what's going to happen is there's going to be a seizing of the money in the account, and the account remains frozen until the issue of forfeiture is resolved. And that can be resolved in one of 3 ways. Now, before I go on to the last and final 3 slides, showing you how the court deals with the issue of forfeiture, don't worry, I prepared a 1-page handout which you'll be able to download if you don't already have it, to keep at hand, which basically reduces all the information in a simple guide covering everything in these slides. So let's turn to the next slide now to look at the potential outcome where the Magistrates' Court is satisfied that the whole amount stated in the account freezing notice was obtained from unlawful conduct. If the Magistrates' Court is satisfied on a balance of probabilities, on evidence presented to the court by the Crown, and they're not satisfied by any competing evidence presented by your client, then the amount stated is forfeited. And of course, once it's forfeited, the account is then immediately unfrozen. Another possible outcome, outcome B, if we turn to that slide, where we can see it's always possible that the Magistrates' Court is satisfied that only part of the amount stated in the notice was obtained from unlawful conduct. And then only that part is forfeited, and the account is then unfrozen. But it's not unfrozen immediately. It's only unfrozen after a 48-hour delay to give both parties time to lodge an appeal in the Crown Court within 48 hours. So what will happen is the amount the magistrates decide will be forfeited, and the account will continue to be frozen for 48 hours and then unfrozen if there's no appeal. But if there is an appeal, it continues to be frozen until the appeal is determined, which must be within 30 days of the order being made. So this can't go on and on. That issue of forfeiture has to be decided and appealed to the Crown Court within 30 days. Let's move on to the third possible outcome, outcome C in the next slide. This is where the Magistrates' Court is not satisfied that any part of the amount stated in the notice was obtained from unlawful conduct. Perhaps using the evidence I referred to earlier, a letter from the lawyer in Albania who was dealing with Joe's grandfather's will, explaining and verifying the source of the money. Obviously no money is forfeited, but the account remains frozen for 48 hours, again to give the Crown only this time an opportunity to appeal to the Crown Court within that time. They have to get their skates on, they have to be alive to the possibility of missing that deadline, because if they do, then the account will be unfrozen. But if they do give notice of appeal within that 48 hours, then the account can remain frozen again for up to 30 days until that issue is resolved in the Crown Court. Now, in a situation where the magistrates are not satisfied that any part of the amount stated in the notice was obtained from unlawful conduct, and your client has suffered loss, perhaps because they can't pay for a wedding that was going to take place, or they've suffered loss in being unable to continue running their business, then the provisions make allowance for that by giving people in that position who suffered a loss an opportunity to claim compensation. So let's move on to the next slide, because I wanted to conclude my presentation with some discussion. But just before that, I wanted to recap on the 5 things I wanted to achieve from this training video. First of all, I wanted to help you as a solicitor to prepare for that real-life client scenario of a client wanting help because their account has been frozen and their bank wouldn't tell them why. The second thing I wanted to do was to reveal what was happening behind the scenes at the bank, why they wouldn't explain what was going on, and what's happening at the National Crime Agency. Thirdly, I wanted to talk a little bit about what clients in Joe's position can bring to your firm, because this is obviously a line of work which you can earn money from often the money is being unfrozen from the account. And using the slides, I wanted to do the fourth thing of helping you to understand the step-by-step process of bank account forfeitures introduced by the Criminal Finances Act. Now we're at the fifth and final stage, where we have some discussion, which I'm hoping will give rise to some questions.
We've got a few questions. We're running out of time a little bit, but a couple of questions for Tom Quinton following his talk. So I'm just going to fire those at him one by one. The first question is, are the 48-hour deadlines extended over weekends and bank holidays? So I'm going to put Tom on so he can answer that first.
Hopefully everyone can hear me. Good question. It's a very good point. But in fact, the legislation makes it clear that the 48 hours doesn't take into account Saturdays, Sundays, bank holidays, or Christmas Day. Thanks, Tom.
Next question, I'm just going to leave you up on the screen. The next question is there anything Jo can do as soon as she becomes aware that her account has been frozen that might assist the bank and speed up the chance of the account being unfrozen? For example, supplying hard copies of her father's will.
Well, that would seem logical. But no, once the account is frozen, the bank is prevented from having any conversations with Joe about what's going on because of the tipping off provisions. But what Joe could do is, before the money is transferred into her account, she can let her bank know that it's expected and send them the information that verifies the bona fides of the transaction. So one needs to be thinking ahead rather than dealing with the problem once the account is frozen.
Thank you. And the final question then, Tom, is can the 31-day moratorium period be extended without an application for an AFO?
Yes, the moratorium can be extended, and actually I misstated this in my presentation, saying the court has to, if it's going to continue, make an asset forfeiture notice. But of course, the NCA or any law enforcement agency can apply to the court for it to be extended. The point I was trying to make is, by that point, a court needs to be involved. It cannot be extended just by the NCA unilaterally deciding it needs time. So thank you for that, because that clarifies that.
Thanks, Tom. So those are the questions we've had from everyone. Thank you very much for participating in this, our 10th webinar. We hope to see you next week, where we've got a couple of really interesting talks, as was this week. Next week we have Deanna here talking about sentencing mentally disordered defendants. And we've also got Dr. Aparna Rao talking about the right to protest in the context of COVID-19 and the restrictions we've got going on. And you may have seen that she had an article about that in The Secret Barrister, so it'll be building on the themes there. Hope to see you next week. You'll find out we'll be sending out LinkedIn links and emails and things of that nature during the course of this week. But thank you very much for participating, and that's the end of the webinar. Have an enjoyable rest of the week.